You see things vacationing on a motorcycle in a way that is completely different from any other. In a car, you're always in a compartment, and because you're used to it, you don't realize that through that car window, everything you see is just more TV. You're a passive observer, and it is all moving by you boringly in a frame. On a cycle, the frame is gone. You're completely in contact with it all. You're in the scene, not just watching it anymore, and the sense of presence is overwhelming. That concrete whizzing by 5 inches below your foot is the real thing, the same stuff you walk on. It's right there, so blurred you can't focus on it. You can put your foot down and touch it any time, and the whole thing, the whole experience is never removed from immediate consciousness. Those words are from the classic 1974 book, Zen and the Art of Motorcycle Maintenance. Well, the federal government ruined a man's moment of Zen in Nevada not long ago. And we're going to ask today whether Congress unconstitutionally delegated to those federal officers the ability to ruin that moment of Zen. We'll discuss that, plus free speech, this week here on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Monday, May 19th, 2025. And although I like having a moment of Zen every now and then, I am very excited this week because we have someone on, a guest who we have been discussing and having on Short Circuit for a very long time, and I'm so happy that he is finally with us. So we will get to him in a moment. First, though, I'm going to introduce someone I am also very happy is on the show, and it is my colleague, Mr. IJ Texas, Arif Panju. Arif is back on the show, and once again, between his last appearance in this one, his office has grown even more. So we have IJ Texas, which I think when I started had like 3 people. It now, he just told me, is about to go up to 18. So it's a very Texas-sized office down in Austin. Arif, welcome.
It's great to be here. Thanks for including us. And like the rest of IJ, we're squarely focused on the impact that IJ can bring. So all good things in Texas and across the country.
That's right. It's a lever large enough, Texas-sized lever that's going to move the world. So we'll get more to Texas in a moment, where things actually aren't all hunky-dory always from the free speech point of view. But we will now move to our special guest. So Casey Maddox is a longtime feature of anyone who's been around the free speech protections or religious liberty protections or limited government, all that good stuff. Casey is at the center of it. So if you've been involved in any of those issues the last few years, I'm sure you've come across Casey's name. He has worked various places. He was at Alliance Defending Freedom for a while. He's been at Americans for Prosperity, and these days he is at Stand Together, their legal director. And I am so excited to welcome him to Short Circuit. So, Casey, what's going on?
Hey, Anthony, thanks for having me on. Looking forward to this. It's always been great working alongside AJ on these issues. And so I need to hire you as my publicist, though. That was quite an incredibly kind intro.
Was I accurate?
I did. That worked. Yeah. So I serve as I'm vice president for legal strategy now at Stand Together, which is as some of your listeners may know, but Stand Together is basically the broader community of organizations which Americans for Prosperity is a part. Stand Together is a large part of what we do is grant funding and other strategies that are aimed at trying to actually make constitutionally limited government happen. So I'm on the CLG team, constitutionally limited government team, which is going awesome. Thanks for asking. And so, but that's my job there, working on everything from the rights issues, First Amendment to due process, and then also the structure questions, which end up obviously driving a whole lot of what happens when it comes to the rights.
Right. So we do a lot of talk on rights here on Short Circuit, but of course Structure is important to real constitutional law, as Justice Scalia used to say. So we have, but although to have real constitutional law, you have to have real limits on government. And this thing, the non-delegation doctrine, has seemed to have not really any limits, which makes it not really a thing, which brings us to this case. So this guy, I got to say, he doesn't seem like a model client. He's maybe not one we put on an I am IJ poster, but he seems to have some spirit because he's taken this case all the way to the Ninth Circuit. And what's his story?
Yeah, so Gregory Pheasant. This case is not, in fact, about a bird, right? This is not Bird Law, the Bird Law episode of Short Circuit.
That's next week.
Yeah, that's right. So Gregory Pheasant, with a group of friends, is riding his dirt bike in the Moon Rocks area in Nevada, just north of Reno. And a group of them out there riding at night, and they're stopped by a BLM officer, Bureau of Land Management, not Black Lives Matter, different people. So the Bureau of Land Management officer pulls him over, and several of the guys, the full version of the story is they stop all of them. He drives off. BLM officer ends up chasing him down. He spins his tires, throws rocks at the BLM officer. So in that sense, yes, not the ideal sort of submissive client who is working with the officers here. But basically, at the end of this, he ends up getting a ticket for having a license plate or his no tail light on his license plate on his dirt bike in the desert.
And they also had their lights off, right? But that's not what he was ticketed for.
Well, yeah, basically it was the missing license plate light. That's what he was targeted. What he was ticketed for. And so he goes and talks to a federal public defender and asks the federal public defender to defend him in this very important matter of a ticket for having a no tail light on his dirt bike. And the federal public defender says, "Okay, well, we're gonna take this on." But one of the claims that I want to bring is I think the Bureau of Land Management, I think this whole order is unconstitutional because I think Congress could not appropriately delegate to the Bureau of Land Management the power to create these criminal laws. And so this is essentially a traffic case now in the Ninth Circuit. And it's in the Ninth Circuit because the government appealed, because the government lost in the district court in Nevada. Federal district court judge said that he thought this violated the non-delegation doctrine. Essentially, Bureau of Land Management controls in Nevada about over 60% of the total land mass of the state of Nevada. Congress had delegated to BLM the power to essentially just manage the entirety of that federal landmass, and that they had the only basis for this law. There's no congressional statute that governs how to deal with traffic violations in 2/3 of Nevada or anywhere else that BLM controls. It was basically just a regulation created by BLM. So you have an executive branch agency that is enforcing the law, an executive branch agency that created the criminal law. It's exactly the sort of problem that if you've kind of brushed up on your Federalist Papers, that the founders would have been concerned about. One person in charge of deciding what the law is, enforcing the law, and so that's what happened here. It's relatively small, right? It's a relatively small fine, your criminal punishment. But in the realm of constitutional law, it's pretty significant, the power that BLM was exercising here.
And it's basically the statute said issue regulations necessarily to implement the provisions of the act that regulates this land. And there's nothing about, it's not like there's a specific law about traffic management, and within that, they then get this regulation about a tail light. It's just kind of go regulate the land.
Yeah, that's right. So it's the Federal Land Management Policy Act from the 1970s authorizes BLM to, quote, issue regulations necessary to implement the provisions of the act with respect to the management, use, and protection of the public lands. So it's sort of a long sentence that essentially just says, go forth and manage the land, which is what a king would do, right? You're the sovereign. You have the power to go forth and manage the lands. It's another way of saying just exercise sovereignty over this land. And so they did that by creating this whole system of traffic violations, essentially, right? They've done a whole lot of other things too, but that's essentially what's at issue.
And so when we look back as the cases that each side are claiming here, there surprisingly there are not a lot of cases that say that Congress has this limit on what it can delegate to the executive. But exactly where that limit is hard to define because Congress, it seems, keeps basically getting away with it. So there was this one good year for the non-delegation doctrine in 1935. There were a couple cases during the New Deal where the court said, come on, it just says basically president has the power to do good, essentially, and that was unconstitutional. But ever since then, it's been there. Even kind of the flimsiest of language allows for that, for the executive to come up with whatever regulations it wants. And so this was very unusual in that the district court was just said, look, that is just too far. But it seems like the Ninth Circuit thought, no, this was okay.
Yeah, so you're right. I mean, this is 1935 is sort of your one good year for non-delegation doctrine, right? It's sort of like you've probably talked a lot on an IJ podcast about the rational basis test.
We do from time to time.
And very often we talk about how the rational basis test is really no test at all. Well, the intelligible principle test under non-delegation is somehow even less of a test than rational basis. It basically just says that when Congress is delegating power over to an administrative agency, it's going to be sufficient as long as it provides an intelligible principle. And other than those two cases, Panama Refining and Schechter Poultry, both in 1935, everything else has been deemed an intelligible principle. And as Justice Scalia points out, that includes even things like it has to be consistent with a public purpose. That's sufficient. Or in the public interest. So if you're essentially just telling an agency regulate in the public interest, right? Well, it's Congress's job to decide what is the public interest. That's the whole point of Congress. And so if that is sufficient, then really there are very few limits. But the court has indicated an interest in trying to kind of more broadly to try to start reining in some of the executive branch overreach that we've seen, right? So you had the Chevron decision last year in Loper Bright. You got the Jarkissi decision last year, where they started reining in these executive branch administrative law judges, right? And the court even has a non-delegation case right now pending, which is the Consumers Research case. So in the Gundy case, obviously a few years ago, the court was seeming to indicate an interest in trying to reconsider its non-delegation jurisprudence. So there is hope. And this district court decided, well, look, this is too far. So the case gets heard then by the Ninth Circuit. And as you indicated, we do have a decision from the Ninth Circuit. And that decision is, look, this is going to be sufficient. It's a pretty short opinion, which is a little surprising, actually. I listened to the oral argument. This is a good evidence of what we all know to be true, which is that you can never gain too much confidence from listening to an oral argument.
Right.
The argument went quite well, surprisingly well, I thought. And so there was some hope coming out of that. But then the Ninth Circuit ultimately said, look, it's sufficient. The statute tells the agency, that it has to manage this land with an eye toward the long-term value of the land. And that was an intelligible principle that allows the Bureau of Land Management to sanction a guy for a missing license plate tail light.
I'm still trying to figure that out, but maybe it'll come to me eventually. It does seem to me, I mean, taking the case law into perspective, that two of the recent decades in this area, one is there's an EPA case from 2001, I believe, where what Justice Scalia wrote, which said that the statute did not violate the non-delegation doctrine, and that the Congress had said that they could regulate air quality at a level that is requisite to protect public health from the adverse effects of the pollutant in the ambient air. And so that was an intelligible principle. Then we get to the Gundy case, which we don't need to bore the listeners of all the details, but it was a criminal statute, and the court was split, but the court had came very close if it had a full bench, because Justice Kavanaugh just hadn't quite been put on the bench yet at that time, to find the law unconstitutional. And since then, though it hasn't bitten, but as you said, it may soon. It seems to me, so putting those precedents together, it does seem to me that this is beyond either of those, where it's just managed lands and you come up with a taillight regulation. I guess one counter to that would be, when they say managed lands, if the court had found this taillight regulation, violate the non-delegation doctrine, does that mean all of the regulations managing lands would be unconstitutional? And that might until Congress acts, which we know it doesn't do anymore, that might cause a lot of chaos on a lot of federal land. I wonder if that's going on in the background.
Yeah, there is the Bureau of Land Management itself, right, it's a weird agency. We sort of get used to this idea that this thing exists. You step back from it, and if you tell a normal person that, there is one federal agency that manages, it has virtual complete control over 2/3 of the state of Nevada. Like, Nevada has an entire governor and state legislature, all of that, right? And then there's a federal agency that manages 2/3 of the state and creates all the criminal laws and everything that just apply to that area of land. That doesn't seem right? Like two branches of a state legislature and a governor, all of that for essentially for 1/3 of the state of Nevada, and then 2/3 of it, you get, whoever is appointed by the president and confirmed, that guy just manages that land. So it's weird in that sense. But I think, from a realpolitik perspective, I mean, the thing I like about this case, and I should say, so we have a bad decision, at least from my perspective, from the Ninth Circuit. I think the en banc petition would be due in June. They have an extension, and so we expect the federal public defender is committed to fighting this case. So he's going to take this up. I will say, by the way, a number of amici weighed in the Ninth Circuit. I think a number of states state AGs filed in support of Mr. Pheasant. And then Cato and AFP and PLF and NCLA and a number of groups ended up filing in support of them in the Ninth Circuit as well. So, but yeah, I think it's BLM is, it's a criminal case, which should give us even more concern than we otherwise might about the idea of delegation, because you've got Congress delegating away the power to potentially put somebody in jail.
Right.
Even an unelected person who can make the decision that you're going to jail. That seems problematic. And this BLM that has sovereign-like power over so much land, if Congress is going to be asked to be very specific about what power it's delegating, you would think it would be about criminal statutes and with respect to an agency that sort of exercises what looks like actual fiefdom. You would expect that those would be the two areas where you'd want to be specific, and you put them together here, and it's pretty breathtaking, the power that they have.
What one quirky kind of inside baseball thing I'll say also about this case is, right, since Justice Gorsuch joined the court, a lot of the energy about, and also Justice Barrett, a lot of the energy on non-delegation doctrine has kind of gone into this major questions doctrine, right? Because we've had these cases where the court rules that something violates the major questions doctrine, and Justice Gorsuch has said in concurrences that, well, this is a way to kind of do some of the work of the non-delegation doctrine, but in a statutory way. Well, unless everything is a major question, I think this thing about a taillight is not.
Yeah.
And so no court's going to wriggle out of this one just saying, well, this is a major questions doctrine thing. It's you have to face the actual non-delegation doctrine.
Yeah, it's a major question to Greg Pheasant, right?
Right.
But in the grand scheme of things, this is like I began. This is a traffic case in the Ninth Circuit. So it doesn't come with all of the negatives that would come along with, well, we're talking about closing down 20 different coal power plants, or we're talking about these major cases that are impacting large sections of the economy, or the tariff cases, right? Instead, this is it really means something to this guy. Mm-hmm. And so I think it has that advantage. I will say, by the way, too, we're talking about this guy. I got to read this one piece from the district court's opinion, just to give you a flavor of this guy. According to the district court, at the end of or after he got the citation, right? He walked over to his vehicle, revved his engine, showed his taillight, put his fist in the air, and rode away yelling. I love this guy. Greg Pheasant is my hero. By the way, I think he's somewhere around 20-ish years of age. He's a young guy who may have ridden his dirt bike into an opportunity to actually restore constitutional government, which would be great.
Well, Reef, there's a lot of dirt bikers in Texas, I would imagine. Your thoughts about this?
Many dirt bikers in Texas, but also framers before dirt bikes were ever invented, which I think is where this boils down to. I think that the framers' devotion to the separation of powers should, I think, impress on the court that its conviction to the vesting clauses are exclusive. And so when power is vested in the legislative branch, the question really is, does this intelligible principle do the work that we expect the separation of powers to do to protect liberty? And I think this particular case is just yet another example of how boundless a standard this intelligible principle has become. And that along with prior cases, it confirms that this principle just doesn't adequately reinforce the Constitution's allocation of power, of legislative power in this case. And so, I hope the court takes up a case and strengthens it, because I do think that just like in rational basis review La La Land, it's not difficult to articulate something at a level of abstraction that is very pro-government. So whether that's a rational basis for why the government can deprive you of your property or economic liberty, or here, a broad intelligible principle about managing land in a sustainable way. And if that's the test right now, it's hard to see how the separation of powers does the work that it's designed to accomplish in this setting. And so, I do think that the votes are probably there to rein it in. I think that when Gorsuch dissented in Gundy, that you had the chief join, you have Kavanaugh in a separate case later on pointing to that dissent, and he kind of lays out this three-principled framework, the first of which seems to have some more teeth here. I think he would ask that Congress has to announce a, quote, controlling general policy, end quote, when passing legislation that governs private conduct. and then authorize another branch to, quote, fill up the details. But not in a vacuum. Congress also has to set forth, according to Gorsuch's proposal, quote, sufficiently definite and precise standards to enable Congress and the courts and the public to ascertain whether what's going on, Congress's guidance, is being followed. There's a couple of other factors that he wants in there, like prescribing rules governing private conduct that may have to depend on executive fact-finding, regardless of how consequential that may be. And that Congress then perhaps could assign executive and judicial branches some non-legislative responsibilities. But what we have right now here, as this case that Casey ably laid out, is kind of like a carte blanche to agencies. And that's what's been going on for a long time in different contexts. And the court has, I think, rightfully started to rein that in, whether it's deference in the rulemaking context with Chevron, whether it's the absence of being able to seek an Article III court. And here, whether you should benefit from the structural protections of the Constitution that did all the heavy lifting before they were eroded. And that's why the separation of powers is important. There's a reason that the amendments are doing so much of the heavy lifting in litigation. It's because the structural ship has weakened. And part of that are principles like this that are so loosely in the government's favor that, I mean, like Casey mentioned, it's almost impossible to find an outer limit where the government has gone too far, except for those two cases back in the 1930s. So it's time to get another one up to the Supreme Court and to rein in what the legislature should be doing, which is performing its function and not delegating it.
I will say, so this case only involves, I think, a vesting clause argument, right? It doesn't have a due process, because there's also a due process kind of non-delegation argument that's in some cases too. But this is just about the vesting provision, right?
At least on the appeal.
Okay.
The federal public defender threw a lot at this in the district court. I mean, God bless him. I mean, this is it's really impressive lawyering. The district court even noted that he did such an excellent job of briefing the non-delegation claim. You probably don't expect that out of a federal public defender in a traffic case, right? But yeah, on appeal, it's because the district court just decided the case on non-delegation grounds. That's the question for the night.
Right. Yeah, I believe the Lopez case from 1995, so the first case since the New Deal period that found Congress to go beyond its enumerated powers. I think that was originally brought by a public defender in Mr. Lopez's defense. Threw that up there and went up to the Fifth Circuit, and somehow it worked. So, as we said in a case with Arif's colleague Jessica, you gotta love those public defenders and doing God's work and not making God's salary. But we will now turn to things free speech. So in Texas, even in Texas, in some universities, there are speech codes where maybe you can't say everything that is protected by the Constitution. And so there was this lawsuit. But as often happens with public interest lawsuits, the government changes its mind after the lawsuit is filed and then tries to wriggle out of facing any consequences. And so we are left with this case at the Fifth Circuit, asking the question as whether there is still something to sue about. So Arif, tell us this story.
Absolutely. So the case I'm going to talk about is a case coming out of the Fifth Circuit. Just came down on May 14th, Speech First Incorporated v. McCall et al. McCall et al. Are named plaintiffs that work at the Texas State University, either as president, chancellor, or the Board of Regents.
And where is Texas State based?
And Texas State is in a beautiful town, San Marcos, Texas, the beginning of the hill country, where you can grab a tube, float down beautiful spring-fed water, drink some beer, and call it a summer, and do that on repeat. It's really a great place about 20 minutes outside of Austin. If you come to Austin and you want barbecue and fresh water to float in with a nice cold beer, San Marcos, or San Marvelous, as many like to call it, is your place.
Oh, I'll remember that.
Well, I'm going to kick this off by invoking the words of our host, Anthony Sanders, a blast from December 2019. And this is at the conclusion of a piece about this very issue. And it ends like this, quote, "Judicial engagement means not cutting the government a special deal in the courtroom. And that includes not letting it cut and run when it is poised to lose there, especially when the Constitution is on the line."
I wish I could remember writing those words and take credit for it, but I'll take your word for it, Reef, that it's from as brilliant a mind as mine.
And it's in a great article titled, "When is the Government Done Violating Your Rights?" From 2019. And the reason I wanted to start with that is because this case really is about judicial engagement, and it centers on a doctrine called the Doctrine of Voluntary Cessation. Why is that important? Because oftentimes the government is sued and taken to court. IJ does this, other folks have done it, and here, Speech First is doing it, and then faces a kind of bait and switch tactic, where it forces the court to develop something to prevent this, and that's what the Doctrine of Voluntary Cessation is. It prevents defendants in lawsuits, including when the government is the defendant, from stopping challenged behavior to moot a case or to stop the case in its tracks, only to pick up the unconstitutional conduct afterwards when the case goes away. And it's a pretty high bar that defendants have to overcome, and for good reason. A court can still rule on an issue unless it's absolutely clear that the challenged activity cannot reasonably be expected to occur. So this is what's at issue in this particular case. And to set the stage, Speech First is a nonprofit, and it is composed of different students. They have sued different universities. And this group had sued the University of Texas in the past, back in 2020. And now they're suing a school just outside of Austin, Texas State University. And the reason they did so is because Texas State University has adopted a harassment policy that reflects that, at least according to the Fifth Circuit, that reflects a principle that's just not in sync with what you'd expect a university to do, especially vis-a-vis the First Amendment, especially when you're trying to nurture discourse and the exchange of ideas on campus. So the university prohibits, quote, "unwelcome verbal," end quote, or unwelcome, quote, "written conduct." And the policy doesn't define what is, quote, "unwelcome," or what constitutes verbal or written conduct. But it appears to forbid speech that some individuals or groups could find uncomfortable, namely speech about race or color or national origin, age, sex, religion, disability, veteran statuses, the list goes on. And that some who may be reasonable could find offensive or hostile. And so free speech is at the center of this, and Speech First, in their complaint, alleged that this policy will be used to target politically disfavored speech on these topics. And so it brought a suit to challenge the policy under the First Amendment, and also filed a motion for preliminary injunction, which is where the crux of this case stands as it makes its way up. So the district court holds two, and what happens in the district court is important to how this cashes out in the Fifth Circuit. So the district court, faced with a preliminary injunction motion, holds two hearings on the PI. And the record reflects that the district court judge agreed with Speech First's constitutional concerns, noted that the Texas State University system, quote, had a, quote, "real problem," end quote, and that the policy had, quote, "critical First Amendment issues," and that it would stifle unpopular opinions, quote unquote, and prevent students from providing their viewpoint to other students. And so the district court recognized and outright said that Texas State was, quote, "going to lose," end quote, on the merits. That's a pretty strong signal that of the factors that you need to satisfy to get a preliminary injunction, the key one of which that you're likely to prevail on the merits.
Otherwise known as going to lose for the other side.
It's pretty clear what's going to happen. Now, but the district court didn't issue a preliminary injunction. Instead, it held another hearing later. But before it did so, at this first hearing, it pressured Texas state officials to amend the policy. And university officials still vigorously defended this policy before the district court and continued to do so in the Fifth Circuit. Eventually, counsel for the university relented. They reluctantly amended their policy. And at the second hearing, the district court dismissed Speech First's preliminary injunction motion as moot. And so the Fifth Circuit gets this appeal from the challengers in this case who want their PI. They want to be able to enjoin this policy. And at the heart of this is whether voluntary cessation by the university is sufficient to render this motion moot and to end the path that Speech First wants to get some sort of injunctive relief. And so the court starts this off by first addressing standing, because the one thing that the university challenges is that Speech First just lacks standing to even take this up. And lucky for them, since they had sued the University of Texas back in 2020 and standing was challenged in that case, the court was able to look at a standing decision involving this exact group, Speech First, challenging a speech code, finding that there was standing. And so the standing question gets disposed of pretty fast. And then it proceeds to lay out the voluntary cessation doctrine and why it matters. So this is a decision written by Judge Ho, along with Judges Duncan and Oldham on the 3-judge panel. And Judge Ho kicks off with just describing the doctrine at first. So voluntary cessation, or just merely stopping what you are doing after it's challenged, does not moot a case just on its own. So just stopping does not. If it did, as the Fifth Circuit reminds everyone, courts would be compelled to leave defendants free to return to their old ways. And so the test for mootness in these circumstances is necessarily stringent. The Fifth Circuit's words, not mine. And to become moot due to voluntary cessation, that can only happen if, quote, subsequent events made it absolutely clear that the alleged wrongful behavior cannot reasonably be expected to occur. That's the test. And the Fifth Circuit finds that this case falls far short of this stringent standard, and that the Texas State University officials come nowhere close to satisfying it. At the outset, the court recognized that, there is no voluntary cessation going on. And the reason there isn't is because the university never voluntarily did anything. What happened was, it took one PI hearing and the district court judge leaning into the plaintiff, the defendant government officials, to say, hey, you should change this policy. You're going to lose. This violates the First Amendment. And still, nothing happened until the second hearing where opposing counsel acquiesced and said the officials were going to change the policy. And so, the court finds that this fails on multiple levels, but that's the first one. You can't just stop your conduct and walk away and think that you can moot a case that way. IJ faces this regularly, not all the time, but the government will, in response to a lawsuit, just stop the offensive conduct. But you need more to be able to deprive the court from reaching the merits, especially when we're raising constitutional claims. The same here. And so Judge Ho then pivots and says, okay, well, even if voluntary cessation applies here, if this doctrine applies, Texas State is still unable to meet the doctrine's stringent standard. And the decision points to the 3-factor test that's laid out in the 2020 case involving the University of Texas and the same challengers. And this test is important because it's the part of the analysis where you need to reflect that subsequent events have made it absolutely clear that this would not happen again. In other words, that Texas State is not just going to resume doing the thing that is being challenged on the First Amendment. Now, the first of these factors is that the government needs to have a controlling statement of future intention. And here, the university had not issued a controlling statement of future intention. In fact, it continued to defend this policy vis-a-vis the First Amendment, even in the Fifth Circuit, just like it did in the district court. And so that's a problem. Second, the timing of this also matters. And so the suspicious timing of the change also factors into the analysis. And here, the old policy was on the books before Speech First sued. The university changed its policies after the complaint was filed. And in fact, in this case, the school changed its policies only after judicial pressure was applied in the context of the plaintiffs asking for a PI. And the university makes no attempt to explain why this expedient timing took place, just leaves it there. Third factor, also important, is that it looks to what the university is doing. And here, whether or not it's continuing to defend the challenged policy. And that's what's happening here. The university is still defending the legality of its original policies, the ones that it sort of changed to try to get out of the lawsuit, and that the district court found sufficient to moot any PI that may be entered in plaintiff's behalf. The Texas state officials continue defending this policy in the district court, and as the Fifth Circuit says, quote, they continue to do so to this day, end quote. And that's the nail in the coffin here. And the government can try to go through the motions of, taking an exit ramp to avoid constitutional accountability, but there has to be doctrines that apply that tilt in the favor of liberty, in the favor of challengers. And here, the university officials came nowhere close. They responded to a lawsuit. They only responded to judicial pressure being applied. It took 2 hearings for the PI to render it moot based on their so-called voluntary cessation. They continued defending the policy, and the suspicious timing of it, I think, together led the Fifth Circuit to say you're not going to overcome the factors that are here. Speech First is entitled to a judicial determination on the preliminary injunction. Now, Speech First doesn't get everything it wants in this lawsuit. As we all also know, it'd be great to have the Fifth Circuit then turn to the merits, grant the PI, and send this case back down. But the Fifth Circuit declines that invitation. They leave that matter to the district court in the first instance, just as the Fifth Circuit did in the 2020 case involving the University of Texas and Speech First as well, and remands this to the district court to reassess the preliminary injunction. And so with the denial on mootness vacated and a remand back to the district court, Speech First is on its way back to get a injunction. And I think this shows that the doctrine is working as intended. Now, should it take such obvious judicial pressure to trigger a finding that these officials in particular can avoid an injunction or the merits of these claims? I think not. I think the timing of it, the mere fact that they kept defending their policy in the first instance is sufficient to deprive them. The judicial pressure on top of that, I think, was just the icing on the cake. And that's what we've got here. It's a doctrine that we have to litigate sometimes to ensure that our clients remain protected, that the government doesn't get away with escaping accountability. And it's something that courts are going to have to continue reminding government officials, as they did here, that when constitutional rights are invoked, it's incumbent upon our federal courts and state courts to engage on the constitutional questions, not just find the exit ramp to avoid doing so.
Now, Casey, we haven't talked in detail about your litigation days, but I think you've seen quite a few cases like this, right? Where you're talking about speech codes, what people can say. And I'm sure you've been down this road before about, has the government done enough to escape a judgment?
Man, I'm getting PTSD listening to the description of this case. So I think I've litigated against universities in about 30 states.
Damn.
I have a specific recollection of being in a court in Iowa and having this I feel like it's the exact same conversation where on one hand, I'm feeling really good going into court because this policy is so completely ridiculous that I can't possibly lose, right? But unfortunately, it's so ridiculous that I so can't possibly lose that the judge is so on my side that he's trying to talk the university out of making him write an opinion to say that. And so, I can't do anything about the fact that the judge is basically telling opposing counsel that you're going to lose. So instead of us spending our time here in court, I'm going to send you into the back and tell you to work this thing out. I'm like, well, I don't want to work it out. I want you to just give me an opinion. Tell them that their policy is unconstitutional. Write me an opinion. And so, because one, I want the confirmation that this policy is done, right? I don't want any possibility that it's not done. And I want every other university to know you can't adopt policies like this. So I had all of these cases, but really relatively little case law on university speech policies. And the reason you get very little case law and a lot of open questions about how exactly these policies work are exactly situations like this. Universities know that there's almost never any actual money involved, so they're not going to have to pay damages. So you can basically get advisory opinions, essentially from a federal district judge who will tell you, is this going to work? Or is it not going to work? Well, it's not going to work. Oh, okay, well then we'll work this out. And frankly, changing the policy is as easy as, you can literally, in a case against Maryland, Baltimore County, scribble it on a napkin at council table. Here's our change policy, Your Honor. So if you can do that, there's very little incentive for the university to actually figure out what the law is and get its policies right. But you got Texas. It's not as if Texas State was unaware. Fire has told them their policy is unconstitutional. I'm sure that ADF has written them a letter at some point telling them, look, this policy is unconstitutional. They've heard it from multiple different directions. But there's really no reason why they should bother going and fixing the policy until you're forced, because it's there's the incentives are very poorly aligned for university counsel in these contexts.
Right, and then the worry is, okay, so the case goes away, you change your policy. What's to prevent them, when people have forgotten about this a month or two later, a year or two later, from going right back to it?
That's exactly right. So I mean, what you want, right, is a system where before you go to the point of creating a speech policy, putting it in your student code of conduct, making copies for every student at Texas State, sending it to everyone. You want a system where someone along the way is actually incentivized to figure out, how would the First Amendment apply to this policy? And let's make sure we're crafting a policy that's actually consistent with the First Amendment before we go and create a student code of conduct and send it to everyone. And that, I think this case is a great illustration of how those incentives are not presently well aligned to make that happen.
So I'm curious, from all your experience in this area, when you've come across this voluntary cessation issue, has it been, in your experience, litigated much, went on appeal much, like this case and then that case from 2020 that Arif was talking about? Or are those pretty rare examples of actually pushing on this cessation issue? Because in my experience, there is surprisingly little on it, especially where the government loses.
Yeah, there's not a ton. I mean, you have all of the sort of associated questions around it. So like the Uzabunam case that went to the Supreme Court a few years ago, right? That was a case that I initially was part of the team when we filed that case at ADF.
And that was nominal damages.
That's right.
Right.
So it's the associated question of nominal damages, right? Because usually these student speech cases involve $0, but they involve something much more important than money, and that's your constitutional rights. And so the problem is trying to figure out, all right, well, how do we assess that so that after they've changed their policy, or at least alleged to have changed their policy, can we still get a determination that what they did to me violated the First Amendment, so that they and everybody else will stop doing it? And so that helped in that respect. But yeah, I mean, this is very often these cases will resolve by settlement agreement. The university will usually just change their policy and tell opposing counsel, after 2 years of fighting you, telling you that our policy was perfectly constitutional, a position that we don't take back. We still think it was perfectly constitutional, but here we've eliminated the offending word that you didn't like, right? It no longer says that. Now please go away. And so you'll argue about whether or not the case has gone away, and that will provide the opportunity to at least come together and say, okay, well, we need these other changes made to the policy, and you're going to pay us X amount in attorney's fees in order to make this go away. And that's usually sort of where the fight is. And then at least, if it costs them something to do this, that's helpful. But usually it's pennies on a dollar in attorney's fees. and it's negotiating over what other changes we would want to see to make this go away. And
I feel like one thing that happens here, what's happened in the district court reminds me of something I don't like that happens in rational basis cases. And it's when the court starts stepping out of its truth-seeking function, where it goes, in some versions of rational basis review, the court will help the government come up with a rational basis. You get an Article 3 co-counsel. That's not, what other setting do you have a judge helping one side but not the other? And here you've got the judge kind of leaning in on the government saying, why don't you change this? You're going to lose. This avoids entry of an injunction. That's what their lawyers should be advising Texas state to do. The court, faced with a preliminary injunction brought by folks, especially believing that the Constitution is being violated, is, I think should be fully within its truth-seeking function to issue that injunction. And not kind of beat around the bush with kind of prodding the government to kind of do something different. The court is a separate co-equal branch. You've got the university exercising its power, and you've got plaintiffs that have decided to show up in the judicial branch to insist that their rights are protected. And that's what should be guiding the court, not nudging the government to change things so that it can access an off-ramp to being held accountable in a written injunction that describes the many ways that its policy violates the First Amendment. Much like the government should not be dreaming up rational bases for challenge restrictions to help the government save a challenged property or economic restriction when the government can't defend that on its own. And so at the heart of a lot of this is judicial engagement. And so whether it's voluntary cessation or whether it's an ability for the courts to get into the crux of the issue, like the intelligible principle being so watered down that you're kind of just accepting these delegations and not flexing the separation of powers as they're intended. I think that common thread is judicial engagement, and we can see it across the board, including these two cases.
Yeah, it's basically, if Chief Justice Roberts has said that the courts call balls and strikes. Well, in a case like this is the court making a mound visit, right? This is not the court calling balls and strikes. This is the court wandering out to the rubber and telling the pitcher that you might think about a slider here. I've noticed this guy really doesn't like them high and tight. Like that's basically what you've got a court here doing. And the court probably thinks it's being engaged, right? It's just judicial engagement that's outside of its actual function. You're not here to try to sort of manage this situation to a supposedly good outcome. You're here to do your job. Engagement in your lane is very good. Engagement in another lane is very bad.
Meddling engagement.
That's right.
You might call it. One thing I think that might be going on in this particular case too is most of the work is really done by this precedent that involved the other Texas university, but also, although Judge Ho doesn't cite to it in the opinion, there was the case last year, FBI v. Ficre, if I'm saying that right, which was the no fly list case about voluntary cessation. So the fellow wasn't able to fly because he was on the no-fly list. He sued about it. They take him off, and this happened to a lot of different people who were on the no-fly list. They take him off and then say, "Oh, voluntary cessation," and he's like, "Well, how am I supposed to know if you're going to get on the list again in the future? I need the court to hear my my argument." And so the court said that yes, there was no voluntary cessation there. That basically that the federal government didn't wriggle out of the case. But more importantly, it clarified something that was a little unclear in the law, which is that there is a burden on the government in voluntary cessation that is the same for all other parties. Because voluntary cessation comes up in all kinds of cases, contract cases, there's a lot of private injunctions, that type of case. This will come up. And so I wonder if that's also working in the background here. The reason why Judge Ho's able to write a pretty short opinion is that everyone now knows that there is this high burden when you have voluntary cessation and the government's the defendant, and it's not different just because this is public policy or the government that's at issue. So that is something to keep in mind as maybe some listeners are involved in cases such as the one that Casey has litigated in 30 states. But we're gonna let Casey get back to his important work at Stand Together. That luckily doesn't take him 30 different states litigating, although he does some important work even so. And Arif does important work down in Texas, and we'll be sure to get him on the show in the future. I should also mention that Casey, in the past, he and I talked about having him come on to do a state constitutional case because he's also like big into that whole thing. And we will put a rain check for that at a future date. So we're going to have Casey back on sometime to talk state constitutional matters. But for now, it's been great talking First Amendment and non-delegation doctrine with both of you. And for everyone else, please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.